Welcome once again to Lehto's Law. Here's Steve Lehto.
I got this story from a whole bunch of people, including Eric, Ken, and Jeff. And his minivan owner takes Honda to court, claiming vehicle defect causes excessive tire wear. Rick Barrett wrote this. The Milwaukee Journal-Sentinel ran it. Story's out of Fond du Lac, one of those nice town names. It's fun to say. Less than 2 years after he purchased a Honda Odyssey, a consumer says he noticed an issue with the tires he believed was dangerous. The inside shoulder of all four showed excessive wear at 28,000 miles. Now, the man is a mechanical engineer who's kept a handwritten log of nearly everything regarding the minivan he bought new in late 2020. So Honda and the dealership that serviced the vehicle say there's nothing wrong with the vehicle. If there is, it's not something they got to do something about. So he says he wasn't going to keep paying to replace tires that wouldn't last their normal lifespan. He says not willing to give up because as a mechanical engineer with 18 years of experience and a significant amount of automotive background, I knew this was a safety issue. So he filed a complaint with the state and he later sued the manufacturer. Now, the trouble with the tires surfaced in November of 2022. And he said the uneven wear pattern was especially troublesome because it could have gone undetected because it's on the inside. And of course, bad tires here could lead to a loss of traction. So he said a service department manager at the dealership told him they had seen this problem before, including once on a Honda with even less mileage. So he took the vehicle to a tire place who confirmed that for safety reasons, all four tires on his vehicle need to be replaced. So the tire manufacturer expects a 50,000-mile tire life, but we're getting less than half of that before crossing the safe tread threshold, he said. Now, he said he's not blaming the manufacturer of the tire because he believes the abnormal wear indicates a problem with the vehicle rather than tire construction. He filed a complaint against Honda with the Wisconsin Department of Agriculture, Trade, and Consumer Protection. His filing included a 40-page presentation outlining the issue and his documentation. He got a letter back saying that Honda had not responded to attempts at mediation. So they say, look, we got it. We contacted Honda. They didn't get back to us. 3 days later, he filed a complaint against the company in small claims court, seeking his anticipated cost for replacing tires over the life of the vehicle and other expenses. A court commissioner heard the matter and awarded him $7,200 plus court fees. So he said, legal system works. But that hope was soon dashed when Honda successfully appealed the ruling. And small claims court judgments are often rather easy to appeal, the same way they're easy to file. In a June 2024 trial in Dane County Circuit Court lasting less than 2 hours, the judgment was thrown out. The circuit court gave two reasons for granting the motion to dismiss. First, it says that he failed to bring the issue with the tires to the attention of Honda within the 12-month warranty. However, the man says that his warranty is for 36,000 miles. And he'd also purchased an extended warranty that goes out to 120. But the court also concluded that this was a complicated issue that would require an expert witness to explain the problem and say, yes, in fact, this is a design problem. Now, the man himself said that he explained to the court why it's a problem and that because he's got a background in mechanical engineering, his opinion should be enough to get past this threshold. He has a bachelor's degree in mechanical engineering from Michigan Technological University in Houghton, Michigan, go Huskies, and a master's degree in engine systems from University of Wisconsin-Madison. Currently, he's an engineer at Mercury Marine, an outboard engine manufacturer based in Wisconsin. So he appealed the circuit court decision. And on May 22nd, the Wisconsin Court of Appeals granted a new trial, saying, among other things, the circuit court erred in disqualifying him from offering testimony about the cause of the tire wear and requiring him to present an expert witness to replace his own ability to testify. The court elicited only fragmentary testimony from him, prevented him from testifying further, and did not purport to make factual or credibility findings. So on July 7th, the complaint found its way back to Dane County Circuit Court. So that's where we are right now. And it's an interesting question because once in a while you'll hear about something where somebody goes, I've got this problem with my vehicle. It's wearing out tires too fast. It's wearing out brakes too fast. It's consuming oil a little bit too much. And all of these things are things that could happen in most cars to some degree. And I've seen it before where somebody goes, I've got a brand new vehicle. And when I bring it back in for an oil change, you go, you're 2 quarts low. So I started checking my oil, and sure enough, halfway through the service period for an oil change, I'm down 1 quart. Where is it going? Or brake wear. And the weird part about these things is they can almost always point to something else and go, well, the person rides their brakes. This person drives poorly, And if there's a design flaw with a car and there's tens of thousands of them on the road, why don't they all have this exact same problem? Now, you're going to say, but Steve, I heard in the story a moment ago that the dealership said they've seen this before. He said a dealership told me they've seen it once before, making his the second one they'd seen. But the dealership has sold more than 2 of these vehicles, and so it makes you wonder. But again, we're not discussing whether or not he's right or wrong. We're arguing about whether or not he should get to a jury. Remember, a trial, full-blown trial, if you choose to get a jury for your trial, is you getting in and getting a day or 2, figuratively speaking, in front of the jury. And the jury decides whether you're right or wrong. And so what the court's getting at with the expert testimony is that when you come into court, you can't just make all kinds of allegations and just say, that's defective, this is defective, this thing's designed poorly, this caused that. There are things that require someone with expertise to connect up for a jury. The best example I can give you is someone getting medical treatment. Okay? So let's suppose that you got injured and you're suing somebody for your injuries. And part of your medical treatment involved you having all kinds of operations. For you to come into court and say, I was injured, I went to the hospital, got all kinds of operations, give me money, you will lose that case if that's all the evidence you have. Because the other side's going to say, they got injured, but all the stuff that was done to them was unnecessary or unrelated to why we're here. They had pre-existing conditions. They had bad doctors. So you will need to bring in an expert who's going to say something to the effect of that the treatment that they underwent was medically necessary to a degree of certainty that a doctor such as myself, you get a witness as a doctor, having reviewed the records or having done the work myself, it was necessary. And it's one of the things that I think a lot of jurors are surprised by when they get brought in to hear a case, if they've never served on a jury before, and all they've seen is what happens on television with lawsuits, is how much of this stuff is put in that's simply there to underscore the validity of the claims. And so in this case, if you said, Steve, back way up and start from square one, and you actually are going to handle this guy's case, and you're going to take it to a jury, what do you need? I immediately need 1 and possibly 2 tire experts. I need a tire expert who can look at the tire wear and go, that is a problem. Not caused by the tires, but caused by a design with the vehicle. Then I need somebody, and it could be the same guy, but maybe not. Then I need somebody who can say, I believe the problem is this. And then they explain what the problem is. And so I can think of some wacky things that have gone wrong with vehicles. I had a client once, years and years and years ago, who bought a brand new Jeep Wrangler. And after a specific number of miles, and it was like clockwork, it was either every 2,000 or every 3,000, the U-joints would go bad. And it happened more than once. It wasn't bad U-joints. It's a bent drive shaft or a damaged drive shaft. And the drive shaft had been dinged in such a way that it was no longer balanced properly. It may have been put up on a hoist wrong. It may have bounced over something, but it happened from day one. My client buys the vehicle and it starts going through the U-joints, and the dealership never figured that out, believe it or not. And I had an expert look at it, and the guy goes, yeah, it's a damaged drive shaft. All the U-joints are bad. The drive shaft is bad. Replace the drive shaft and you're good. Problem is they didn't catch it in time to get it outside of the lemon law. But it's not my job to fix the cars. It's my job to figure out what's wrong with them and whether they qualify under the lemon law, okay? So in a case like that, you have to bring in somebody who'd say, okay, jurors, here is what a drive shaft is, for those of you who don't know, and here's a nice illustration of one, and here's a photograph of the drive shaft off of the plaintiff's vehicle, and here is the ding in the side of the drive shaft, and let me explain to you what happens as this drive shaft now spins as it goes down the road. And the vibration it sets up in there eventually destroys a U-joint or two. And not plaintiff's fault, it's probably not a design defect, and it's not really a manufacturing defect, but it is damage that was done to this client's vehicle before he took delivery of it. Now, someone's going to say, but Steve, how do we know he didn't damage it? There was no evidence that he did. And by the way, they never raised that argument. They never raised that argument. So in this guy's case, can he testify to the court and say, I'm a mechanical expert. I have 2 degrees in mechanical engineering, and I've observed this and looked at this and studied this, and I consider it to be a design defect. Here's why. That would be enough to get him to a jury. But I would not recommend that he do that, because obviously he would appear to be a very biased witness because he's got an investment in the case. It's his case. So you go find a professor, someone who teaches this stuff, or you go find somebody who works at a job doing this kind of work, but for a different company. Or believe it or not, there's retired engineers out there who'll testify for you, who'll examine a case, give you their opinion, and testify. You hire one of those experts, and it's going to cost you some money. But if you win, you can often get your money back from the other side. So it's an interesting case, but the plaintiff says that he thinks it's a problem that's across the platform, but we only know of the 2 cases, and one of them is really hearsay. So don't know what to say about it, but it's an interesting case in that he handled the case by himself through the appellate process and won. But now he's hired an attorney and is going to let the law firm that he hired take care of it, which I highly recommend, because I think he'll get further doing it that way. So Eric, Ken, and Jeff, and everybody else, thank you very much. Rick Barrett wrote that for the Milwaukee Journal-Sentinel. Minivan owner takes Honda to court, claiming vehicle defect causes excessive tire wear, and his case is still alive. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Life moves pretty fast. If you don't stop and look around once in a while, you could miss it.